BPEP is Berkeley Postdoctoral Entrepreneurship Program, and the basic mission of this particular program is to foster entrepreneurship among UC Berkeley's postdoc, visiting scholars, and graduate students through education awareness and opportunities as such as group offered by a group like these. It is also to connect the aspiring and entrepreneurs with mentors and resources, and it is an excellent platform because we do connect to a lot of people through networking here. It also catalyzes the productive collaboration on scientifically complex topics, but also how to get economic benefits out of it to actually uh, make it lasting and sustainable. Further, the vision of this program is to create an empowered UC Berkeley postdoctoral and graduate student community, and to provide them tools to translate their research into products via startups. And this program was founded by Naresh in 2010. And this is the current status of, these are the current team members of the program. And the next opportunity, which I'm basically going to advertise about the next workshop in this series, we are going to be having multiple workshops in this Idea to Funding Fall workshop series. And today we are going to be basically talking about the intellectual property and how to translate basically get the visas sorted if you are actually aspiring an international. Sorry about this. It's a typo. I apologize. But how to sort your visa process through, and further. In the next coming workshops, we are going to be discussing about startup fundings and how to basically different types of startup fundings and how to build deep tech startups. With that, I am coming to our first speaker for the evening, Dr. Ali, and he basically specializes in strategic intellectual property counseling in a wide variety of technical fields. And he also specializes in patent strategy, patent prosecution, and diligence. And he has prepared and prosecuted several patents across the world, and also provides legal counseling to companies at various stages of growth. And he has also worked in other fields such as data warehousing, business intelligence, and enterprise data integration. And he frequently lectures at UC Berkeley School of Law and UCSF College of Law on various topics, including patent strategy. And with that introduction, I think, Ali, please, the medium is all yours.
Great. Well, thank you for that, Shivani. That's a fantastic introduction. And Naresh, thank you for thinking of me for this great opportunity. I always enjoy talking to very talented people. And I remember a long time ago when I was doing my postdoc, this is back in 2004, 2005, when I was doing my postdoc at Harvard in chemistry. I was thinking about next steps, and so I can appreciate where you guys are all at. So just briefly about my background. I got my PhD from Stanford. Sorry about that. I know you guys are all UCs here, and I got my PhD at Stanford in chemistry and catalysis. Research was focusing on catalysis. And how surfaces of catalysts change during a chemical reaction. Did a postdoc at Harvard, basically in the same field, looking at gold and titanium oxide nanoparticles on gold surfaces. And then I decided to do a complete change in my career. Went into patents in 2005 because I wanted to work with companies with really awesome ideas. And I'm sure you all have many awesome ideas. I've been doing patents for over it's been about 18 years now, and I've helped with many companies with different types of technologies in many different spaces, in the life sciences to materials to clean tech to tech. Now we're doing with things with all things machine learning / AI. It's a very big field, and for me as a paddler and a scientist and an engineer, it's been really fun to see all these spaces grow and evolve. What I'm going to talk to you guys today about is I'm willing to bet that each and every one of you has a very special idea about something very cool. And we want to make sure that no one gets to take that idea and potentially prevent you from what you are entitled to. So we're going to talk about ways of protecting your very valuable ideas. And when you guys go on to your next greatest things, whether it's a startup or whatnot, whether it's a company, you will for sure have ideas. And steps that you take to protect those are extremely important. I'm now seeing too many times in my career where people either take ideas, or more frequently ideas of similar type are generated at about the same time. One very famous example is the whole CRISPR-Cas battle, which actually UC is a part of it. Broad and the UC were basically invented at almost exactly the same time, and in almost exactly the same field, with whole prime editing and base editing concepts were developed at about the same time. So what I'm getting at, and what I will touch on, is how you protect your ideas is critical. It's extremely important. We want to make sure that you guys get the credit that you deserve for your ideas going forward. And I do have slides to share with you guys all to go through. I'm going to share my screen, and please feel free to chime in with any questions you may have along the way, and we'll keep this as an open discussion. The name is Alemozafar. I'm a partner at Wilson Sonsini. I've been doing patents for 18 years, roughly. What I'm going to touch on today, team, are basically, first of all, what is IP? Intellectual property. What does that mean? And when we think about IP, ways of protecting it, there are basically 4 ways. One is trade secrets, trademarks, patents, and copyright. My focus will be on patents and trade secrets, but I will touch base on these other 2 as well, just so you guys have a sense of what these are and what they are used for. Why do we even care about IP? Well, it's really to secure rights. We want to make sure that rights to your ideas are covered and value is preserved. We want to also protect value. For startups that are very early stage, even companies in certain spaces, the way that you capture value is through steps that are taken to protect the intellectual property that overlies various concepts and ideas, whether it's a formulation, a method of processing waste, a new type of battery, whatnot. There is IP there, and it is important, it's critical that IP is protected, because as you guys move forward, whether you want to raise money, secure partnerships, have a downstream acquisition, or go public, or even generate revenue, the steps that you take to protect your IP, your concepts, and to preserve value is important. It's the most important thing for a company. And how you protect IP allows you to assess and to manage risk, of someone copying your ideas. Trade secrets is one form of ways of protecting IP, and that's very simply, it's there to protect concepts that are of business value, and the value comes from those being kept as a secret. So for example, the formula for Coke, a very specific algorithm for ML, for machine learning, a very specific formulation composition or concentrations of ions in a formulation. The very specifics, which are difficult to figure out through spectroscopy or whatnot, those being kept as a trade secret, those are protected, and the value is kept. The risks with trade secrets are that if someone else were to come up with the same concepts independently, then the trade secret can just evaporate. So we want to think about how to strike a balance between trade secrets and patents. Patents are a government right that protect various things, like a device, an apparatus, a combination of matter, a process, whatnot. These have a term of about 20 years, and they're generally the same from one country to another. You have to disclose what the invention is to get a patent. And the risks with patents are who owns them. So making sure that the assignments are locked down, making sure that when you guys have companies, that your company owns those patents. They can be expensive and they can be challenged. But this is not to prevent us from filing patents. These are all risks of the game. Patents are a very powerful tool to preserve value. And I would probably say that for most of you, your concepts will be protected by these 2 means of protecting your concepts. Other ways of protecting IP are things like a trademark. That's to protect the mark of your company, for instance, of your product, whatever, things like Google, Adobe, Coke. Those are protected by way of trademark, and it's fairly easy to get for marks that are distinct. Copyrights are there to protect works of authorship. For example, source code. You have written your fantastic machine learning algorithm, and you have written software code around that. That code is copyrighted. These two are fairly uncommon in the world that I operate in, just because startups, their names can change. Copyrights are, of course, important, but the power of a copyright is generally not as great as that of a patent. So we want to, again, be thinking about patents and trade secrets. This plot shows the protection or power of the form of IP coverage versus cost. At the very high end are patents. These are the strongest. These also cost the most to secure, because you have to pay lawyers and scientists to write these up for you, to negotiate a patent for you with the patent offices, not just in the US, but in Europe, China, Japan, India, and various top markets for whatever inventions you guys want to commercialize. One step down is a trademark. That's where you have to file a trademark application with the USPTO. And so there is money involved because you have to pay lawyers. Then one step down is a trade secret. There's no form to fill out. This is just a trade secret exists by virtue of you having a concept that is kept a secret. That's also of business value. So it's actually quite simple to protect a trade secret. You just have to put anyone that has access to it on notice that it's a secret and it's to be kept as a secret. So using NDAs are important there. And at the very bottom here is a copyright. So the moment that I have written, and I used to do this, when I used to code, the moment that I wrote my source code down, it was already copyrighted. So the cost is actually fairly low from that standpoint. Now we're going to focus on patents. That's the world that I live in, and for companies in spaces that I heard you guys operating in, whether it's the life sciences, batteries, materials, clean tech, patents are going to be extremely important. You want to be thinking about patents. Even in machine learning, patents are now important. It's, in fact, there's been a surge of patent filings just on machine learning over the last few years. A patent is a government right that allows the holder of the patent to exclude others from making, using, or selling what the patent covers. What that means is that when you get a patent, there is no automatic police that goes out there and says, this company is infringing your patent, and we ask them to stop. You have to actually go out there and look for the copycats, for others that may be infringing your patent. But the patent is there and it's public, and it's a stop sign. It's a stop sign that you've secured through your tough work and your brilliant ideas. And it is given to you by various governments that you are interested in, various countries. And it is there for 20 years. It has a term of 20 years, roughly. Some countries like the US give you some additional term if there are any patent office delays, but the term is roughly 20 years. They're country specific, so you have to file for patents in countries that you are interested in. And with a patent, you can stop a competitor, or you can approach them to get a license, but you have options for how to monetize your patent. Moving on, there are various ways of, various things that you can file a patent on. You can file patent on software, on algorithms, on a user interface. For instance, Apple versus Samsung, they fought each other years ago on over 7 design patents on just the look and feel of the iPhone mail app. When you swipe down and the mail app shows that it's updating, they had a design patent on that, Apple, and they sued Samsung and they won. Over 7 design patents. But design patents are, generally speaking, not as powerful as utility patents, which is the world that you'll most likely live in. It's a formulation, a composition of matter, a composition for a new type of anode for a battery, whether it's a lithium anode or sulfur-containing anode, whatever it is. These are utility patents, and that's what we focus on mainly. And the majority of patent filings are utility patents. Design patents are still important, but they're fairly rare as compared to utility patents. Patent versus copyright, you can protect your software through lines of code by way of copyright, but you can also protect the overarching algorithm through a patent. So you can think of both. Even for those of you who have software, think about how to capture the value of your hard work through a patent filing. And guys, by filing a patent, we're not talking about stopping or hampering innovation. We're not talking about going out there and suing people. We're talking about preserving value. We want to capture your hard work, because if you are a software company, and I get this frequently from software companies, is why should we go out there and stop others from innovating? Well, the patent system was built to foster innovation. By giving us ways of capturing value, we're actually motivating innovation. And rarely do we see lawsuits over patents. Most patents do not get litigated at all. They're used to capture value. They're used as part of acquisitions by larger companies, or when you go public, Wall Street will be caring about your patent filings and patents. They're there to capture value. And in very rare instances, are patents actually litigated in the courts. Those are fairly rare. All right. Just very briefly more on software. There are some challenges to overcoming issues at the patent office to getting software patented, but these are mainly issues for lawyers like me. If you have ideas that are more on the software side or algorithms, think about protecting them through a patent as well as trade secrets. Okay. And I frequently get asked, why should we file patents versus keeping things as a trade secret? If I were to keep my invention as a trade secret, great, I can just protect it forever, right? Well, the answer is not necessarily. If your invention is something that you're planning on selling, like a battery or a formulation for a therapeutic drug, or if you're going to be selling a service as a diagnostic, or whatever it is, and you're going to be putting your invention out there, someone might be able to figure out what the invention is. And if that's possible, then the trade secret value is fairly low. You want to be thinking about patenting. With trade secrets, the risk also is that someone else can figure it out. If I were to figure out the formula of Coke and go out there on Facebook and post it, Coke's trade secret evaporates. And they can do nothing to stop me. They can do nothing. They can't sue me because I figured it out myself. I can take Coke, figure out a way to figure out what the formulation is, what the composition is, and publish on it. And if I didn't steal anything from Coke, they have no way of suing me. They have lost their secret sauce, which is why we want to be thinking about patents and also leveraging trade secrets for the very specifics. I want to maybe talk very, very quickly about here some patent essentials that I like to make sure that all of my inventors are aware of. These are sort of tips here, tips, if you will. Treat all of your ideas with extreme confidence. Assume that your ideas are worth more than gold. And you may be talking to a friend, or you may be talking to someone who works at a company that you may want to join or partner with, or maybe you want to hire someone. Keep your ideas fairly high level. Keep your thoughts and what you discuss at a fairly high level. Do not get into these specifics. And if you have to get into the specifics of what your invention is, get an NDA in place to protect the confidentiality of your discussions, because we want to avoid your discussions being counted as prior art against you going forward. Keep records of your work, of your experiments. You guys maybe you conducting experiments to prove something or to develop something. Please keep track of that so you can later say what you did to be able to write your patent, and you can maybe figure out who the inventors are, what the specifics were. So keeping records is very important. For when you guys join companies or you form companies and you guys are further along, there are ways to capture inventions through forms that your company can have, and we can give those to you. I can send those to you guys now, free of charge. It's just a form that you can fill out with your inventions for patent lawyers to then use to write your patent. And when you have a product later, you can do what's called patent marking, which is to mark the product when that is being sold in the market. So marking your product with a patent number is important. And as part of your company's future business strategy, making sure that you have a patent strategy that aligns with your business strategy is extremely important. We don't want to be filing on patents on just anything. We want to be filing on patents that are of business value. And importantly, we want to be thinking about making sure that your patent strategy aligns with your business strategy. That's what we think about as a firm. And my specific practice is making sure that a company's patent strategy aligns with their business strategy. Getting into some more specifics about patents, if you go out there and you talk about your invention publicly with someone, it could be a talk. You may submit a manuscript to Nature or Science with your invention. You may go on a blog post and put a blog post about your invention. You may go on Facebook or LinkedIn and type something. You say, well, I've discovered this fantastic new composition for use as a lithium containing anode for a battery. No one else has ever done it. And you were to post that on Facebook. That could actually hurt you from filing a patent around that invention going forward. That's a publication. It's a public disclosure. And what happens is, with that public disclosure around the world, with the exception of the US, so for Europe, China, Japan, India, and these other markets that are large markets, you will not be able to get a patent around that invention. Your own public disclosure will hurt you. The US, though, gives you 1 year to get a patent on file. You get that 1 year runway. But by talking about your invention publicly, others can then take that and innovate on it. And worse, someone else could file on it. That's possible too. Someone else could. So the tip is, please do not talk about your inventions publicly until you have filed a patent, because we want to make sure that your own public disclosure or even sale of your product doesn't hurt you from a patent standpoint. The patent process team, guys, has a lot of deadlines upon deadlines upon deadlines. Those will annoy you. I'm just going to prep you now. When you guys file patents, and some of you may already have filed patents, you probably know what I'm talking about. The process of getting a patent is annoying for inventors. I've been through it myself. Many times I've done it. And it's annoying. It's many deadlines. You have to argue with these examiners at various patent offices who will try to say that your invention is not that special. And it's my job to prove them wrong and to help to move that forward. And lastly here is, when you're talking to hiring someone to work with you, or some of you may be thinking about forming a company as a startup, and you're thinking about other co-founders and so on. Before they invent, make sure that you guys have established a company, and each of you is under an obligation to assign your rights in inventions to that company. So having assignments in place is important, because we want to make sure that your company owns the inventions that are being developed. Great. Okay. I'm going to briefly go through how to get a patent. It's a process that's fairly complicated and it's fairly involved. I do see your hand there, actually. Yes, Domenico.
Yeah, hi. Thank you, Ali. Just one question on your last point. There was that you gotta have a company, you said, before filing any patent, right? Is that right? That means that you gotta set up a company, and then you have to go through the bylaw process and all of that before, even deciding who is gonna get those right, but before deciding who's gonna get what, right?
Yes, exactly. Now, sometimes you may have already come up with concepts, like you may have ideas now, and you want to form a company after. So what you can do is you can form your company, and typically, startups set up a Delaware corporation. That's the most common, is to set up
no partnership, right?
What's that?
No partnership.
Yes.
Or just limited companies. Okay, yeah.
Just the most common route for startups is to incorporate as a corporation, a Delaware corporation, and once you have done that, you can then, as part of the incorporation and as part of your employment, you can actually assign your rights to your ideas to the company, so that your company owns the IP. That's going to be very important. Your investors will be looking for that. Your investors will not put money into a company that doesn't own the core IP. So, which makes sense, right? And it's very common for inventors to have invented before they've even set up their companies, but it's very easy to fix that. You can then set up the corporation, then assign your rights to the company. Very easy. Yeah, good question. Great question. Yeah, absolutely. Guys, so how do you get a patent? Well, first, the invention has to be of the right subject matter. So it's got to be either a composition, an apparatus, a method of doing something. It's a fairly easy hurdle to overcome. Generally, there are some exceptions like for software, but we can even overcome those. So it has to be of the right subject matter to get a patent around. That's the very first hurdle. Your invention has to be new. It has to be yours. You should have been the very first to have come up with that, and that's called novelty. It has to be non-obvious, which means it has to be very special, and I'll talk about that in a second. And then, as part of the patenting process, when you write a patent application, you have to describe to the whole world what the invention is, how to make it, how to use it, and so on. And in exchange for telling the whole world what your invention is, you get a patent. At the end of this runway, you will get a patent that then gives you 20 years to basically be able to extract value for that invention. So that's the trade-off between patents and trade secrets. Trade secrets, you don't have to tell anybody anything. In fact, by definition, you should not tell anybody anything. You keep it as a secret. The term of a trade secret is potentially infinity. But the risk with a trade secret is that someone else can come up with it independently of you and even publish on it, and then that trade secret would then evaporate. So there are trade-offs there. Novelty is fairly straightforward. Your invention is new if no one else out there has talked about it, has published on it anywhere. So if you have an invention around something, and before you came up with this invention, you find a science article where someone has talked about it, then your invention is not novel. But if you don't find anything on it, then your invention looks like it's novel, and you should go forward with filing a patent if the invention is of business value. Obviousness is tricky, and I'm going to go through it, and at the end of this explanation, I'll give you guys a tip about obviousness. But I will go through it first, and then I will give you a tip. Obviousness is really saying this: your invention is new, but it's not that new. So that's what obviousness really amounts to. And maybe to illustrate this by way of an example, suppose your invention is a light bulb. You have invented the light bulb, and back when you invent the light bulb, you look around and no one else had talked about, a glass enclosure with a filament that's then filled with some sort of inert gas. No one else had talked about that. You're the very first to have done that. So your invention is novel. So assume that you have invented the light bulb and it's novel. When you try to get a patent, though, the patent officer at the patent office says, your invention, which is the light bulb, is obvious because out there, before you invented the light bulb, people had known about glass enclosures, glass bulbs, that was known. And tungsten wire was known. And inert gas like argon or helium was known. So because these various bits and pieces were known, your invention, which is the light bulb, is obvious. That's what obviousness means. And that's what happens when you get challenged, when you try to get a patent, and that frequently comes up. It's a huge disservice to an inventor to say that their invention, which is new, is not that special. This is For me personally, as a patent lawyer, it's a huge disservice to the genius and talent that comes to invent things. Which is why my tip to you guys is, don't worry about obviousness. Don't worry about it. As long as your invention is novel, or you feel like it's novel, think about getting a patent. Don't worry about it being not that, if it's not that special. I've seen many times now in my career, too many to even count, where someone thought that their invention wasn't that special. They knew it was novel, but they thought, oh, well, this is obvious. It's really not that special. When in fact, it was super special. Obviousness is for lawyers to worry about. There are various tricks that we can use to get past these issues. For you guys, as the talented inventors and the experts and the scientists and engineers, only worry about novelty. As long as your invention is novel, think about getting a patent. Just made your lives easier. And don't worry about what lawyers tell you. If lawyers tell you that your invention is obvious, talk to someone else. Come on and talk to me free of charge. You can talk to me and we'll have a second chat about it, get a second opinion. Okay, any questions about novelty, obviousness, and patenting requirements? Okay.
Can I quickly, sorry.
Yes.
I do have a question there.
Yes,
so in terms of the idea, if the idea is still like about there, but nobody has really applied it, is the application part also a part of like you showing that this can be utilized? Is that also a part where you can actually patent?
Absolutely. Yeah, 100%. In fact, there's a very well-known space in science, in the life sciences specifically, that is based on that alone. Therapeutics. The field of therapeutics is in a large way, you see a lot of therapeutics where a known compound is being used in a new way. Known compound used in a new way is patentable. And multi-billion-dollar therapeutics companies file patents and get awarded patents, and they make a lot of money on using a known compound. It's known, the compound was known, but it's being used in a new way. So even that is patentable and quite valuable. Good question.
Thank you.
Great question. Yep. All right, guys. I've talked about these sort of throughout the last few slides, but first of all is we have this requirement of absolute novelty, which means before you talk about your invention publicly, file a patent first. It's that simple. File first, talk later. And actually, even when you file a patent, be very careful about what you talk about, because you want to maintain your first mover advantage. So that's why companies stay in stealth mode for a long time, and it's just to prevent others from getting advantage of their concepts and skipping past steps. So first mover advantage, file your patent before you talk about your invention publicly, please. I mentioned that in the US, you have this 1-year runway to file a patent, even if you talk about something publicly, but we don't want to rely on that, because these days, for most companies that I work with in most spaces that I work in, whether it's the life sciences, materials, clean tech, and whatnot, we're thinking about also getting patents in Europe, in China, Japan, India, Australia. And these markets outside the US, once you talk about your invention publicly, that public speech can be prior art against you in these other countries, and it will actually defeat your ability to get a patent. So file first before you talk about the details of your invention publicly. This plot here, this slide is confusing, and it is intended to be confusing. It just shows that the patenting process is complicated. It has many deadlines, many points at which something can go wrong, and it's just the way it is. It's just the way that the patent systems have been built up, where you have all these dates and various decision points to worry about. When you guys are thinking about filing patents, please talk to a patent lawyer or patent agent about this process. There are various ways for law firms to work with you. For startups, we can help with cost and so on. So to help with you guys. But when you file a patent, you have a lot of deadlines to meet to basically help move your patent application through the process to become a patent. And if these deadlines are missed, they cannot be fixed. Usually they cannot be fixed. So it's quite important that you guys work with someone that can help you with this whole process. There are two types of patents in the US, provisional and a non-provisional. A provisional application is a very nice way to get a patent application on file. So you get your filing date, which is good. You have filed your patent application, which is great. The filing date is strong around the whole world. So by filing a patent application in the US, your filing date is good in the US, Europe, China, Japan, India, Australia, the whole world. Which means then you can go and basically talk about it, and then your own speech will not hurt you in any country. And one nice way of doing that is a provisional. This is fairly quick. It's fairly inexpensive. It has to be done right. It has to look like a patent application with these things called claims, figures, and a description. A provisional patent application gives you 1 year to add updates to the invention. So if you guys file on a new therapeutic compound and then 2 months later you have updates to it, you can get those updates in before you have to file a regular application to then get the whole process started. I frequently use this for my companies. It's a very nice way to also extend the runway to not having to pay the expensive lawyers' fees. This does slow things down on the patent side. It's going to, if you are a startup and you want to delay these expenses, this is a very nice way to do that. And one thing that's important to remember, guys, and for me to point out here is with provisionals, you want to avoid the issues and the pitfalls with filing weak applications. There are some companies who may file a couple of slides. I've seen one company at one point file a napkin as a provisional, with a cover sheet, and they filed it. Those are weak. Those can actually hurt you. You want the provisional to look like a regular application, to have the strength of the filing date actually matter. Otherwise, the filing date may not be very strong, and you may have a false sense of security that you can go out there and talk about it. So it has to be done right. It has to look like a regular full patent application for your filing date to actually be good. I mentioned this before, you want to make sure that your company has a patent strategy. We're not just filing patent applications and patents just for the sake of filing, but there's a strategy. And for us as a startup focused firm, I make sure that my company's patent strategies align with their business strategies. So each and every patent that's filed aligns in some ways with the company's business strategy. That could involve covering what the company does. So we want to make sure that your patents cover you. And quite importantly, we want to file patents that could cover someone else. So cover your potential competition out there, who may be competing with you. We want to be thinking about covering them too. You want to file on updates and improvements frequently to get those locked down as well. And you want to work with IP counsel to help you get this done, just to make sure that nothing goes wrong. Yeah. And we can share these slides with you guys to have access to it offline. I'm happy to send this around. So we want to have objectives as part of our IP strategy. Work with a lawyer to help you with that. As part of your business strategy and your company's IP strategy, at some point you will also want to think about freedom to operate. Freedom to operate is looking for whether there are patents of others out there who may stop you from doing what the technology is. It's important, guys, for me to help note here that when you get a patent to your invention, that patent will allow you to stop someone from doing what that invention is. But what your patent doesn't do is it doesn't give you the freedom to practice what the technology is. It's a little weird, but there may be patents out there owned by others who may cover certain aspects of your technology. And you want to also do a search for those patents and make sure that as you continue to come up towards commercializing your inventions, whatever those are, that you are not stepping on any patents of others out there, because you want to avoid getting sued. You also want to avoid getting someone suing you and say, hey, you're suing my patent, please pay me royalties, or even worse said, they'll just sue you to just stop you. The way to avoid that and to manage that risk is to run a freedom to operate study when the time is right. And that's it. Perfect, Shivani. Great. So I'm going to stop my screen share and see if there are any questions.
Great. Thank you so much. This was very informational talk.
My pleasure.
Do we have any questions?
Ali, I have a quick question.
Yes.
One thing that comes up is about filing international patents, which is pretty expensive for a startup. And people are always scared that others are going to steal it. How does an early stage startup deal with filing internationally? Any advice on that?
Great question, Naresh. Yes, fantastic question. Very common pathway is to file a provisional, which when you file a provisional, you have them 1 year to file internationally. So it buys you 1 year, and then that 1 year, you can also time it such that you also factor in raising money and building into your budget the expenses for the downstream filing internationally.
Any things not to do? Mistakes people do in that, like I want to cover China. It's all expensive. Like people can't comprehend how expensive it is.
Very common mistake that I see companies make is because they listen to lawyers that do not have a lot of experience working with startups, is they may file multiple applications around different but related inventions. At the very beginning, if you want to keep costs down, combine all of your costs into fewer filings. So one provisional, I actually prefer omnibus filing. So omnibus filing means it's a kitchen sink filing. Take all your ideas, put them into one application, file it, and that'll help you keep costs down. You don't lose anything whatsoever from the ability to file many patents from that downstream, but upstream, you'll save a lot of money that way.
Thank you for that. Andrea?
Okay, thank you, Ali, for the talk. I don't know if maybe I'm going to do a question, like maybe it has been done before, but I had problems with the speaker, so I missed some parts. I was wondering, okay, what happens if now I have an idea here at UC Berkeley, and the IP will belong part to the university, I guess, no?
Yeah, it depends. If the idea relates to your research work there, and if it does, then most likely UC will own it. Very, very common. And then and then when you form your company, you'll then work with UC to get a license to the IP.
Okay.
Yeah. Good question.
I have one question on a similar topic. So what happens if the work that we did is already open access published, and then I wanna implement some of those things from there and file a patent for that?
Yeah, if what you've done at, let's say, UC has been published, so if whatever you have invented at UC is now in your thesis or it's in a science article, so it's been published, and then you leave UC, you can then take that invention that's been published, because it's prior art, and you can innovate on it and file your own patent on it. And that patent will be owned by you, by your company, not by UC, because you are innovating on prior art. You are innovating on prior art. Yeah. So what you have done at UC, if it's prior art and you leave, and then once you have left and you've joined your company, you formed a startup, and you are working there 100%, and you then improve on the UC invention, that improvement is owned by your company.
Yeah. Another thing is like just suppose I write plenty of codes, a software to analyze data or something, and then we publish that data, and then later on I wanna implement that code to generalize it for some other things, some other molecules or something, and then sell it to companies. Would that be?
That may be okay too. You would have to look at, if using the code may be subject to copyright. You want to make sure that if you're taking code from UC, you want to make sure that you are allowed to use that code. If the code has been published, then it's prior art, and you may be okay to just use it. But you want to see if the code, sometimes code isn't published. It's kept hidden, but you want to see what the circumstances are. So it would depend on the circumstances that surround your code.
Okay. Thank you very much.
Yeah. And also, actually, on the same note, be very careful with using open source, because open source libraries, frequently my clients use those for various applications. You want to be very careful about what the end user license agreement for the open source says. You know, you want to be very, very careful about making sure that you are sticking very carefully to that use, and make sure that it is being used in the right way.
Are there any other questions? If not, let's thank Ali for this great talk.
Oh, actually, there's one question from Fuhar.
Oops.
Just curious, any tips on how to convince PIs and University Tech Transfer Office to file a patent? Yeah, it's if you approach, you know, if your invention is of commercial value, you know, if you can say, look, I've come up with this fantastic invention and it has the potential of making a lot of money, most likely your PI and the university will be open to filing a patent on it. You can bring your PI on board as a co-founder or as an advisor, give them shares in your company. It's very common, and they can then help you convince the University Tech Transfer Office to file a patent on it. If the university, for whatever reason, says they are not interested, then they can tell you that, and that's actually a good sign. They can potentially file that yourself, and you could be clear of the university owning it. But if the university senses that there is business value, they'll most likely file a patent on it.
Okay, just one quick question. Like, I was wondering, given your experience, right? Let's say that you have a very good idea, and then you make an incorporation, and then you give your rights to the entity. But given your experience, what's the best way to approach potential investors?
Yeah, that's probably for a separate discussion, because there is a lot to cover. But usually, what happens with spinouts and with people leaving academia and to form a startup is, you know, you have an idea. If the idea was invented at UC and UC may own it, then you should go through UC's Office of Licensing to basically get a patent filed on it, and then you can work with them to get a license to it, or at least an option, and then a license. And then once you've left UC and you are working to generate a pitch to raise money, put together a pitch deck. The pitch deck will have, you know, here's what you want to pursue commercially, here's the market size, and here's why people should be interested in it to invest. And then you work with various advisors and partners to help you get contacts and connections to various VCs. Like us, we have, you know, contacts to every VC around, so we can help make those connections. That's one approach. That's a very common approach.
Okay, thank you. Yeah.
In the interest of time, I think is it okay, Ali, if people can email you with their questions?
Absolutely.
Later on?
Yes.
That's all right. Perfect. Thank you so much. Thanks again.
My pleasure. Thank you all. Good luck. Bye-bye.
Our next speaker in today's series, attorney Paul Herzog. He has over 20 years of experience with employment-based immigration, and his focus is basically to obtain work visas and green cards for foreign students and scholars. And these visas, he deals with different category of visas, including H-1B, E-1, permanent residency-based, national waiver, extraordinary ability-based O-1 visas. And he works with individuals and companies across all the United States. He is based in LA, and he's also a member of American Immigration Lawyers Association. And we're excited to hear from you, Paul.
Thank you for your introduction, and thank you to you and Naresh for inviting me to speak to this very distinguished group. And yeah, and I just want to mention, aside from the professional qualifications, I should mention that I'm also the child of immigrants myself. So it's a personal matter for me, and I'm very passionate about the work that I do. So I want to talk about what are the immigration options for entrepreneurs and startups. Now, by way of context, if I can just have that first slide, in the US economy, immigrants account for about 15% of our workforce, but 25% of entrepreneurs. And they also account for about a quarter of our inventors, and roughly 35 to 40% of new firms in the United States have at least one immigrant co-founder. So immigrants are really critical to maintain the U.S. economy's dynamic edge. So I'm going to talk about, what are your immigration options for participating in that? Okay. First of all, I want to point out there's a distinction between immigrant visas, also known as green cards, and non-immigrant visas, which are temporary visas that let you work and study. Okay. The green cards is why does everybody always want a green card? Because a green card allows you to live here permanently. It gives you pretty much all of the rights of an American citizen. It gives you a path to citizenship. But it's very time consuming and very difficult to get a green card. So in the interim, you try to find a temporary or non-immigrant visa, of which there are quite a few, and the processing times can be faster, but they're much more limited in terms of what they let you do. So what's the most common approach is people look for some type of non-immigrant visa initially, and then transition to the immigrant visa. Okay. So by the most common, it's often overlooked, but the most common visa that can help an entrepreneur is the B1 business visitor visa. That allows someone to come to the US for up to 6 months, and it does not allow employment, doesn't allow paid employment, but it does allow a person to engage in most other business activities, such as securing funding, signing a lease, meeting with potential employees or clients. And so this is definitely an option for people who are outside the US and looking to maybe start up a business here. Okay. The other types of visa are, you can have the next slide. Now, some of you, I'm guessing, are here on F1 student visas. If you're here as an F1 student, one of the great things that you can do that helps you start up a business is to get optional practical training. And I know that at Berkeley, Silk Hollingsworth at the international office probably explains how to do this. But basically, if you're here on an F1 visa, you get, after you're done with your course of study, you get a 1-year work permit. And if you're pursuing a STEM degree, then you get 2 years after that 1 year. Now, the limitations are you have to be doing work which is related to your studies. But OPT can be used for self-employment. So if you graduate and you're setting up a company, that is a permissible activities under OPT. So this is oftentimes what a lot of people do, and that's definitely something you want to take advantage of. The other common visa that entrepreneurs get, especially and I see it a lot with graduate students at a place like Stanford or Berkeley, is the O1A visa for extraordinary ability. Now, the requirements look quite intimidating, and I just want to go over them. You have to demonstrate that you meet at least 3 of the following requirements, okay? Receipt of lesser nationally or internationally recognized awards, membership in organizations that require outstanding achievement. So, for example, that would be like the National Academy of Sciences or something equivalent. Published material about the applicant. Now, this is very important. Published material means, an item in the newspaper or a news media website. It would not mean a press release. Okay, so if Berkeley issues a press release saying the following individuals, did this in their lab, that's not really going to count. That's just a press release from your university. But an article in Wired or an article in a trade publication, that would count. Okay. Service as a judge of the work of others. So if you served as a peer reviewer for a journal, that would count. Or you served as a reviewer for a grant-making body, that would count. Now, oftentimes for graduate students, I see the professor they work with, tells them, okay, please do this peer review for me. I'm so busy, and they do it for their professors, but they're not really getting credit. That doesn't help. It has to be reviewing service where you're the one invited by the journal. Okay, so oftentimes I know people don't do this type of work because they're very busy, but this is something, if you get invited by a journal, you want to do it and you want to document it, save copies of the invitation or the thank you note, because it will help you later on get an O1 visa. Okay, original work of major significance in the field. So if you've been doing research which has gotten attention, which has gotten, if you published an article, they're looking for things like citations, that all helps, okay? Authorship of scholarly or scientific publications, I think that's pretty self-explanatory. If you're an author or co-author on articles published in journals or conference presentations, this is evidence of that. And then the last one, employment in a critical capacity for a distinguished organization. This is a very elastic type of category. So for example, if you're one of the co-founders on a startup that's gotten some attention or that's been funded, that received significant venture capital funding, that would be, obviously you're playing a critical role in this organization. That would be evidence as well. So the O1 is really probably going to be the most useful visas for entrepreneurs. And so, look at these categories, and then, maybe you're not quite there yet, but that's okay, because you can start to think about how you can accumulate evidence in some of these different categories. So the other common visa is the so-called E2 for treaty investors. So the E2 is a visa specifically created for people who want to invest money to set up a business here. Now, the limitation with the E2 is it's limited to countries with which the US has a treaty. Now, that covers most of Europe, Japan, North America, etc. India and China are not covered. These are big gaps. But it can be helpful if you're from one of the countries. And essentially what you have to show is you're investing money to create a business. It can be anything from a restaurant to an electric car factory or movie production. The business has to be majority owned by citizens of the treaty country. Okay, so if you're setting up a company and the majority of the founders are American, it's not going to work for you. But if you're from France or Australia and your co-founders are from that country, this is the vehicle that may be helpful for you. And I say co-founders, I really should say the money. It's you have to show that the majority of the money, the investment, is coming from people from that country. Okay. And there's no particular limit on how much money needs to be invested. It simply has to be the amount of money necessary to make the business successful. So and that really depends on the type of company. If you're setting up a boba tea shop near the Berkeley campus, maybe $100,000 or $200,000 is sufficient. But if you're setting up a biotech company, then you would need much more money. Okay. And part of the application process is submitting a business plan that would show how you're making that investment. Maybe less common for you, but I want to mention this as well, the L1 intra-company transferee. So most of you are already here, so this may not be applicable to you in the short term, but it's something to keep in mind. Companies that want to transfer their employees to the United States, if you're a multinational company, use the L1 visa. The L1 is also useful, and it can be used for a company that wants to set up a new office in the United States. So for example, say you have a biotech company in Taiwan and they want to open up a company in the Bay Area, open up an office. The L1 visa would be how they transfer staff to open up and set up this new office in the United States. Now, that was a kind of a brief overview of the temporary visas. Now, I didn't talk about I didn't talk about the H1 visa. The H1 is the most common work visa that people historically have used to graduate once they graduate from a course of study in the US. I didn't mention it because it has two big drawbacks. One is it's subject to a very severe quota, so it's very hard to get it. And the other is you typically have to show you're an employee of a company, and it comes with a lot of restrictions in terms of salary and so forth. So it's not very useful. I'm happy to answer any questions about it, but it's not real helpful for people involved with startups or trying to create their own business. Now, those were the temporary visas, the whole alphabet soup of temporary work visas. What we all want to transition to is getting the green card, because several of the advantages of getting green cards is it's easier to get funding, it's easier to get loans if you are a permanent resident. So what options do you have to get a green card? Well, when it relates to your work, there's either employer-sponsored green cards, which involves the labor certification process, and that means testing the job market. Your employer advertises your job, or the so-called outstanding professor or researcher category. And there are self-sponsored categories, namely the extraordinary ability and national interest waiver. So Employment sponsored means what it says. You have to, it's not your application, it's going to be your employer's application. The most common way that people get a green card through their employer is known as labor certification. And that involves a test of the job market. Your employer has to advertise the job, file application with the Department of Labor to show they couldn't find a qualified American. It's a very slow, very cumbersome process. And typically it takes, to get a green card that way, a minimum of 2 years right now. And it's difficult because it's got a lot of niggling little requirements, because the test for the Department of Labor is you've got to show that there's no American workers who are willing, able, and minimally qualified to fill the position. Okay. And that's a tough standard to meet. You really have to be very careful about how you phrase your ads, how you, review resumes and so forth. And it's a lot of work for the employers. It also is not going to work if the foreign worker themselves have a stake in the company, a stake exceeding 5%. But it still is the most common way that people get a green card through their employer. Another type which requires employer sponsorship is outstanding professor or researcher. Now, this is commonly used by universities for their professors, obviously, but you can also use this category if you're a researcher at a private company. The requirements are you have to demonstrate things like that you've been a researcher, that you've published articles, you've done reviewing work, and you also have to show that the company has itself a significant research operation, typically, but that they employ at least 3 full-time researchers. But it does work even with smaller startups, as long as they can demonstrate that they have a significant research operation. So this is something to keep in mind. The requirements are, it's a little easier than the O1 or the extraordinary ability I'll talk about later. You have to show evidence in at least 2 of these categories, such as receipt of prizes, service as a judge of the other, authorship of scholarly articles, and so on. But this is an option for you if you've got a company and you can apply in that category. Now, the self-sponsorship categories are sort of really where the action is if you're an entrepreneur. And there's sort of 2 ways to self-sponsor yourself. One is extraordinary ability, also known as the EB-1A green card, and the other is the national interest waiver. Extraordinary ability requires you to show evidence in at least 3 of the following. If you look, you'll see it's very similar to the requirements for the O1. The main difference is immigration, and in my experience, and is that the immigration service is probably a lot more, I would say, lenient with the O1. The O1 is a temporary work visa, so a lesser amount of evidence will get you approved for an O1. But that same lesser amount of evidence, even though you hit 3 of the categories, probably won't work for an EB-1A. They're just more stringent because they're giving you a green card, which is a sort of better. They're just more demanding in terms of the types of evidence. So just because you got an O1 approved doesn't mean you're going to get an EB-1A case approved. They're typically going to want to see a lot more solid evidence in these different categories. Okay, so if you get an O1A approved, don't assume that right away you can apply for the green card. I might, and other lawyers will probably tell you, maybe wait to accumulate more evidence. If 3 or 4 articles might be sufficient to qualify, for example, in an O1 case, but for the extraordinary ability, they're going to want to see more. Okay, so just bear that in mind. But the great thing about this is, it does allow you to sponsor yourself. So let me talk about also the national interest waiver. That's the next slide. Okay. National interest waiver is probably the best way to get a green card on your own that immigration offers. The reason it's so great is the requirements are really pretty flexible. What you have to show is that you have at least an advanced degree, okay, and that you're working in a field of substantial merit and national importance, which is a very broad definition, and that you're well positioned to advance the proposed endeavor, meaning you're in a good position to do the work in this field, and that America benefits from granting you the green card and waiving the requirements of advertising the job. Guidance from a few years ago specifically encourage USCIS to look at things like job creation and economic impact as positive factors. So national interest waiver, the nice thing is you don't have to be a extraordinary ability. You can have maybe just a few publications. Basically, it boils down to this. You have to be able to show that you've done useful and important work in a field which is of interest or benefit to the United States. And they've been very broad in terms of the kinds of cases that I've seen approved. I've done a number of those for startups, including for people with very few publications. So maybe you have very few publications, but the one publication you had was cited maybe 40 or 50 times because it provides some useful guidance on a particular aspect of healthcare or a particular aspect of climate science. That would be sufficient to get a national interest waiver case approved. So, and also it allows for, like I said, self-sponsorship, meaning you can apply on your own. You're not dependent on someone else to file that application for you. And that's the big advantage. Now, what's the big drawback for the green card process is this. We have substantial backlogs in issuing green cards for people from certain countries, particularly China and India. If you're from India, you're looking at a long wait time, maybe 10, 15 years, even if you get a national interest waiver case approved. And I don't see that changing anytime soon. So for people from those countries, and also China, you're looking at a delay of maybe 5 or 6 years. It is a very long wait time, even if you're approved in the national interest waiver. The EB1A extraordinary ability category is therefore more attractive for those individuals because the wait time is much less. Okay, you're looking at a much shorter time, maybe 1 to 3 years to get the green card. So those are the factors you got to consider. Now, I'm going to give the usual disclaimers, which is every individual is going to have a unique situation. So you definitely want to, look at what I'm talking about as just a broad overview, and your particular circumstances, you're going to warrant a very specific solution. So it's always good, you always want to have a discussion with a lawyer talking about your specific factors. Okay, but I'm happy if anybody has any questions to answer those to the extent I have time. Or if you want to email me, it's fine to email me with questions as well.
Thank you, Paul. Do we have any questions?
Paul, maybe you can talk about the most common mistakes people make in picking one of these categories, like and applying. What have you seen in the cases that come to you?
Well, common mistakes, I think a lot of people will assume that maybe they won awards as, one of the criteria is, awards. Have you won prizes or awards for your work for the extraordinary ability category? What they mean by that are national or internationally recognized awards. Anything you win as a student, you won, the class of 1922 Berkeley Prize for best, student paper. That's great. It's not going to count for immigration purposes. So when they mean awards, they really mean awards that you've won at a national or international level. Now, if you're part of a grant or you won a grant from a national grant-making agency, whether private sector or public, that is good evidence. But anything that's sort of within a university is not going to help you very much. So I would just leave it aside. The other mistake I see with people, and especially I see this with people making their own applications. A lot of people want to do it themselves, which I understand. Or they work with lawyers who do this, is they do the kitchen sink approach. And this isn't a national interest waiver or extraordinary ability application. They think, let me just put in everything I've ever done, and I'll just write a 30-page cover letter to immigration talking about every possible thing I've done. And you have to remember the immigration officer reading your application has a stack of 30 other applications that they've got to get through before they can go and have lunch. Your application should be, you don't want to make it too short and too thin, but you have to be able to explain clearly and concisely what it is that you're doing, what's essential and important about it, and and make it easy for them to understand what your work is. Okay. throwing everything, they're not going to give you a green card because your entire career of your entire career. And I've seen people include things they won in high school. Like I was the Science Bowl champion in high school. They don't care. That's not useful to them. You really want to have something that's clear and concise. So it really helps to have a much more narrow focus. In the national interest waiver, for example, what's the clear benefit? Imagine you're at a party you've got 5 minutes to impress the person you're talking to. What would you say is really useful about your work?
Well, I think one other thing we were talking about was like, how early, how late, most people wait till they graduate or the last minute to file for these things, and the money cost aspects of it. How much should they save up before approach a lawyer?
Sure. Well, let me talk about timing. That's always a difficult one. I would say now is a good time to, my goal in giving this presentation, and I give presentations like this all the time, is really to give people a sense of what to think about. For the extraordinary ability, you probably don't qualify at this time, or the O1 criteria, but it's good to start accumulating that evidence. Maybe you get an opportunity to be a peer reviewer. Don't turn it down, take it, because it can help you later on, okay? So in terms of timing, it's helpful to take advantage of things like optional practical training or academic training if you're on a J1, because it gives you that time to start setting up your company, accumulating the evidence maybe. And it's a good, but if you're working towards your PhD, you're going to graduate in maybe 2 years and you're now thinking about being an entrepreneur. Now's the time to at least think and plan how you can maybe make it happen, okay? So that's what I'll say about timing. If you're coming right, if you're like, your OPT runs out and you haven't done anything and now you're calling me and it's going to expire next week, there's not much I can do in a week to help you out, okay? So but if you get your OPT and it's going to expire in 1 year, that's the time when you want to talk to a lawyer and think about how you can plan out what your options might be, okay? Now, in terms of cost, that's the $1 million, literally, or more like the $6,000 question. So my advice would be, I'd love for everyone to just hire me and only me, but really the sound advice is if you're shop around for lawyers, talk to 3 or 4 different attorneys, see who you're comfortable with, see how they charge. Every lawyer charges a different amount of money. They're going to charge differently. Some charge a lower upfront fee, but bill you by the hour over that. Some just charge entirely a flat fee. Different lawyers also are going to have, different lawyers also going to have just different personalities. I think I'm good at what I do, but my personality is going to be different from another lawyer who's also very good, and you're going to be comfortable with one versus the other. And that's okay. So there's that. In terms of fees, though, I would say this. Lawyers who don't, if you talk to like 4 different attorneys and one is a lot cheaper than the others, that's going to be because they're going to spend less time on your case, okay? This type of work is really time intensive for an attorney, labor intensive. And if they're not charging you much money, it means they're not going to do much work on it. And you really want somebody who's going to take the time to really focus and do a good job.
Can I add one more question here, just for the general interest?
Yes.
I think here for visa applications like these, I believe they ask for recommendation letters. What are the kinds of recommendation letters that bear better weight or add value to those applications? Any words of wisdom on that?
The best recommendation letters are letters that are specific. Okay, a letter that says, Naresh Shankara is a great scientist and we need more scientists. Thank you very much. You're sincerely. And I see a lot of that's not helpful. Okay, that's just very generic. But a good letter is something that says, I worked closely with Dr. Sankara in my lab at the University of Washington. He was a critical part of my team, which developed a spark plug that increased fuel efficiency 30% for gasoline engines. And thanks to his work, we got a grant from the Department of Energy to do blah, blah, blah. That's a good letter. Really, I got specifics, I got numbers, I've got like talking about specific work that you did. That's what I like to see. It's not so important like whether the person is from abroad or whether they're from here. It's important that the person be clearly an expert in the field and they talk about specific things you've done that are good for America or that are important to the field, right? Or a letter that says, before the state of the art in our discipline was X, and we didn't have a solution to the problem of X. But thanks to Naresh's work, now we've got a solution to X, and we're able to develop Y and Z. That's good because, again, it gives context about what is the work that you're doing.
Just along those lines as well, if you are to have 3 sets of documents or material ready for you to apply, if somebody in this audience need to be prepared to come to you or file for an application, what would the top 3 be for them?
Well, what for me, when people and they want me to evaluate an application, what all those ask to see is, give me your long form resume, listing all your publications, listing all your, have you gotten any grants? Are you part of a team that got a grant from the NSF or some other government agency? That's all stuff I like to see. So put it all in there, let me see it, and then I'll see. That helps me understand. And then I also tell people, resume, give me a 1-page memo about who you are and the work that you do. What's important about you? Imagine you're coming through the air, like you're coming through LAX, you're at passport control, and the CBP officer has been given the power to give you a green card on the spot. If you can tell him on why your work is important, what would you say? Okay, right. And same like when you're pitching your company to an investor, you're not going to talk all over the place about, you're going to talk about specific, like what your invention is and how it's going to make money for your venture capital backer. So same thing with a green card, there has to be like a specific thing that you've done. So I always tell people, for me to evaluate the case, CV, and then like a 1-page memo explaining what it is that you do. Oh, I want to say one thing. A few years ago, one thing that I didn't talk about is the so-called entrepreneurial parole program. That is a program that was set up in the waning days of the Obama administration, and with a lot of fanfare, but then the Trump administration essentially killed it bureaucratically, and it has not really been revived. It's on the books. You see it mentioned, I think, on the USCIS website, but it's essentially not operating. So I didn't mention it or discuss it because I don't know anybody who's gone through it or anybody, even that they're processing applications. May get revived at some point in the future, but for now, it's not something you can rely or count on.
I have a question, like at what stage one should go for the startups if one is in the process of green card as well? Say for example, in my case, I have been under the process like EB2 national interest waiver, and I also have received my EAD card 6 months ago. But at what stage can I start my own startup? Is it like...
Well, you may well be able to do it right now. If you're at the stage where you've gotten your work permit, and have you filed the I-45? That's
yes.
The application?
Yeah, it's already been like 6 months.
So you're able, as long as your startup is sort of relating to what you did, what was described in your NIW petition, you can go ahead. That work permit lets you work for anyone, including yourself and your company. But,
okay. Thanks for clarification.
And correct me if I'm wrong, Paul, like you can incorporate a company even if you're not a citizen or a green card holder anytime.
Absolutely. So incorporating a company, anybody can do that. Now, there may be some rules from state to state because corporate incorporations are a state level function, and different states will have different rules about who can incorporate what types of companies. That you need to talk to a corporate lawyer. But yes, any individual can create a company.
Thank you, Paul. And thank you all for joining in. And have a good night.